Well, welcome to Landmark Chambers webinar, Virtual Inquiries, a Guide. We're delighted to see so many of you joining the session today, and I hope you find the presentations and the discussion that will follow to be useful and informative. My name is James Maurici QC. I'm chairing the session today. I'm joined by my colleagues Sasha White QC, Richard Moules and Anjoli Foster, whom I'll formally introduce to you in a moment. Can I start with a few housekeeping points? First of all, your microphones are automatically muted, so there's no need for you to adjust your local settings. We very much welcome questions throughout the session. You can submit them through the Q&A section, which will either be at the top or the bottom of your screen, depending on how you've got it set up. And we'll endeavour at the end to answer as many of those questions as we can once we've got through the presentations. The webinar is recorded and you will receive a link to the presentations and the recording shortly after the event ends. And finally, on housekeeping, if you lose your connection at any point during the webinar, we'd simply invite you to rejoin using precisely the same details that you used to join first time. So thank you for joining us for this webinar on virtual inquiries. Who would have thought at the beginning of the year we'd be here this morning discussing virtual inquiries as something that was actually happening. Indeed, even as lockdown got underway, it was far from clear that we would be in early July discussing virtual inquiries as something that was actually happening. We know that the response of PINS to the crisis was not as fast as that of the courts, and that'll be something I know Sasha will be touching on the history of how we got here during his presentation. I think it's just worth focusing for a moment on the courts and what's happened there. You'll know the Lord Chief Justice announced back on the 19th of March that the default position in all jurisdictions must be that hearings were conducted remotely. That included right through the civil family courts, included the planning court, and this happened almost overnight, maybe extraordinarily, but it happened almost overnight. And on the 16th of April, the Inns of Court College of Advocacy published a comprehensive principles for remote advocacy that sets down 8 key principles. And that's worth a read, not just for advocates, but for anyone who's involved in, or going to be involved in a virtual hearing. Thus, the reality is that many months before the first virtual inquiry kicked off in June, the courts were hearing complex, lengthy trials with multiple witnesses remotely. And so there is much for us to learn, and much for PINS to learn, and the planning bar to learn, and planning professionals to learn from what's been going on in the courts as we seek to catch up with the courts. Within the court system, there obviously have been issues. There have also been successes. The experience from barristers and judges has been that virtual hearings have worked well, but they are in no way as good as the real thing. The reaction from lay clients has been mixed, but most are glad that there is some way, even if not a perfect way, of progressing their cases. Certainly a collective view amongst the majority of people in Landmark Chambers is that virtual is here for now, it works, but there must be a question mark about whether it can ever be as good as the real thing. There are, of course, practical issues, and we'll touch on some of those. I think the consensus has been that virtual hearings are more tiring than the real thing, and there are certainly some real challenges in this very much overnight switch to paperless advocacy. There's some challenges ahead for there. But virtual inquiries are here, they're here now, and that's why we're here to give you a guide to that through our 3 speakers. So I'm going to introduce to you all 3 speakers before handing over to Sasha, who's going to speak first. So Sasha White will be known, I think, almost all of you surely by now. You know that Sasha specialises in planning appeals. He's done over 100 inquiries in the last 5 years. He's also been involved in the West Ferry print works case on behalf of the local planning authority, both at the inquiry but also in the High Court litigation, which it's fair to say has received some press of late. He's been instructed by 8 of the 10 largest house builders in Britain in the last 5 years. And you'll also know him from the Have We Got Planning News for You webinars where he recently jointly interviewed the Chief Executive of Planning Inspectorate on her plans for the appeal system. And Sasha in a moment is going to be telling us about what is the current position of PINS in relation to virtual appeals. Secondly, you're going to hear from Anjoli Foster. Anjoli is ranked as one of the top junior barristers in Planning Magazine survey. She regularly appears in public inquiries on behalf of both appellants and local authorities. And over the past year, she's appeared in major public inquiries across the UK relating to various development proposals, including large-scale housing, employment and retail and energy plants. And then lastly, you'll hear from Richard Moules. Richard specialises in planning and environmental law and compulsory purchase. He's on the Attorney General's A panel and is currently advising the Secretary of State in relation to his new First Homes initiative. He regularly appears in the higher courts in planning matters, including successfully acting for the Secretary of State in Monkhill, a leading case on the tilted balance of paragraph 11 of the MPPF. And Richard also, most pertinently for today, acted for the appellant in what was the first virtual inquiry that PINS held in June, and he'll be talking about that in more detail when he speaks. So without any more from me, I'm going to hand over to Sasha.
Thank you very much, James. Good morning, everybody. I am in a very good mood this morning because finally equilibrium has been restored to football and Arsenal above Tottenham Hotspur in the table. So I've already ribbed James, who has the misfortune to support London's second team. So I'm delighted about that. Now, let me talk about what is the current position of PINS to virtual appeals. Now, this obviously could be, I could summarise it in an interesting journey, or I could take a long time. Now, I'm going to take a bit of time because, of course, as we all know, historically there have been three ways of determining planning appeals under Section 78. You've principally had written reps, which the vast majority are dealt with, 91%. Hearings of about 7%, then public inquiries only about 2%. So historically, we can see the vast focus of PINS resources in terms of planning appeals have been devoted to determining matters by written reps. So clearly, that can continue in the COVID world, subject to the issue of site visits. But of course, now we're in a world, as we've just heard with Richard doing the first one 2 weeks ago, we're in a new mode of determination, which is a virtual appeal, which is using video and telephone technology to determine appeals. And when I use, and I think others in this webinar use virtual, we include both visual and by telephone. So, COVID, as we all know, and all of us have had varying degrees of effect, but in terms of virtual appeals, there's been a complete transformation in the approach of PINS. It's a bit analogous to someone who bitches and moans about having to go on holiday somewhere, actually goes on holiday, thinks actually this isn't too bad, then spends the next 20 years going to the same place. And of course, remember, until March 2020, no virtual event had been held by PINS. I'm not even aware of a CMC. Obviously, the CMCs, the case management conferences, were done by telephone since Bridget Rosewell's reforms came in. And now we live in a world where, of course, in June 2020, there is a school of thought, and indeed some inspectors even heard that virtual appeals will be the norm, irrespective of whether COVID is a factor or not in the longer term. And it's interesting what James has just said about the approach of the courts. Now, looking at the future, we're in a world where four things could happen. It could be that we revert back to pre-March 2020, which is probably the least likely, and no virtual technology is used in the appeal process. The second option is only virtual technology is used in the appeal process, which one would imagine was pretty unlikely, but there does seem to be some forces in the Planning Inspectorate who are quite keen on that approach. The third is the partial hybrid approach, which is that you use virtual technology on the same mode of determination, i.e. you would have an inquiry, but elements might be done virtually, like hearing from third parties. Then the fourth option is a complete hybrid approach, which you could have partial virtual technology and different mode of determination on the same appeal. For example, you might have elements done by cross-examination, elements in a hearing and a round table, and you might even ask for some written evidence. And actually, the planning bill flags this up. The intention of what's going through Parliament is an aspiration to give PINS complete flexibility as to the mode of determination and a hybrid approach. So the chronology, it's just worth taking a moment to look at what's happened. And I just mentioned on the 10th of March, Anjoli was being led by me at an inquiry in Woking. We turned up. I raised with the inspector, was there any fear of us not being able to complete the inquiry because of COVID? He said at that time there were no instructions from PINS on the approach to COVID. So on the 10th of March, PINS hadn't yet had any formal position. Then, of course, we got the position of the government, which was effectively to stop non-essential travel on the 18th of March, and our inquiry adjourned. On the 1st of April, PINS identified that consequently, in the light of the government's position about only essential travel could be undertaken, that they postponed all hearings, site visits and inquiry. And they announced then for the first time that they're investigating ways to mitigate the effect of COVID through the use of technology. Then on the 5th of May, the PINS no longer released the stats relating to the average timescales. And on the 11th of May, we know the first hearing was done as a pilot by PINS. It was a scheme in Cornwall, and that decision came out on the 27th of May. So pretty quick refusal by virtual hearing. Then we had a further update from PINS on the 13th of May, announcing the recommencement of site visits. And then there were two further updates on the 28th of May and the 26th of June. So where we are is what has happened in the lockdown. So I've just jumped on two screens. What has happened in the lockdown, PINS are telling us now as a result of their latest missive that 3,500 decisions have been issued. Now, of course, the vast majority of those are by written reps. And just to give you a sense of the effect of COVID, PINS have said that under normal circumstances, let's imagine we were in 2019, they would have expected to have issued 5,600 in that period. So clearly, COVID has had a pretty material effect. About 60% of the appeal decisions have been reached. Of course, if we look at public inquiries, and I'm sure like James, Rich and Anjoli, we've all had many inquiries postponed in March, April, May, June as a consequence of COVID. At the moment, we know from what PINS tell us, there are 60 appeals being progressed as pilots using photographs or video evidence, i.e. to avoid the need for site visits. We know that since the lockdown, 13 local plan letters have been published, 600 site visits in May, 15 hearings are taking place in June virtually, and planning inquiries are also being concluded by written reps. And you'll recall the one I mentioned a moment ago where we turned up without the inspector having a view. But that inquiry, what the inspector determined was he would not hear from the planning witnesses as was intended, but we would effectively do that by written evidence, and then we would conclude by the submission of written closing. So that inquiry was effectively a hybrid in the sense of a physical inquiry followed by a written reps to finish it. Now, we also know that 10 planning inquiries are being held virtually in June. We know there's been one that Richard will tell us about in a moment. And there's also another one relating in Chorley, Lancashire, that Simon Pickles from Landmark has also been involved in. We also know that the South Oxfordshire EIP, which is frankly one of the most controversial EIPs in the country, is being held, and the decision was taken as a result of representations about concern about those that wouldn't have access to virtual technology, that PINS decided to hold that by telephone. We also note that 15 hearings for national infrastructure projects are being held in June as well. So what is the current position in practice? As we know, PINS's latest position is they will not be arranging face-to-face hearings or inquiries for the foreseeable future. And the current position in July appears to be that the programming of inquiries with flexibility to determine how they will be determined in future, and I'm sure like many of the people watching this webinar, I have an inquiry in September, which is currently said it might well be physical, but it might also have to be virtual. The same is being done with hearings. I think that, frankly, and I'm sorry I can't give you more certainty, but unquestionably the position will change again. And I think it is important that everyone keeps an eye on the PINS website for updates. What is now happening is that PINS are asking appellants and local authorities about their views on holding virtual appeals. And I strongly suggest anyone who does have an appeal in the system that is either a hearing or an inquiry think very seriously about their response if PINS come calling and ask for virtual inquiry or hearing. It is noteworthy that I was told by Sarah Richards that of the first 20 pilots that they wanted to hold on inquiries, the vast majority of appellants and local planning authorities were not happy to have their inquiries determined by virtual process. So there was an immediate scepticism, but it's certainly worth considering the arguments both ways. And I'll come back to that in a moment. So the future, I think, as Richard will identify, the future is, as a result of the success of the various virtual appeals that are being held and the EIPs, that more will be held. And there is no question, do not doubt for a second, that PINS are seriously considering virtual inquiries or hybrid inquiries permanently. We take the view at Landmark, for our little role in the planning system, but we take the view that they're unlikely to become the norm or the only means of determination due to problems with full participation from third parties, but most importantly, inspectors. Obviously, the recruitment and retention of inspectors is critical. And frankly, if you are condemning people to spend their lives looking into computers, I think that is a serious problem compared to the ability to interact with people physically and have a physical inquiry. Additionally, and all of you who are interested in this, there was a strong New York Times article about this about a month ago, which looks at the physical effects of looking at computers and screens, and looking at Zoom or Teams unquestionably causes a kind of specific and unique type of exhaustion and is much more physically demanding. And as Richard will come on to deal with, it's affected the hours on which inquiries sit virtually. So going back to my point, and this is something I leave you before I hand over to Anjoli, is the pros and cons of virtual appeals, and have a think about this. As I say, PINS will come calling and ask you from your respective positions what your view is, whether you be an appellant, a third party or a local authority, or indeed an inspector, or we know we've got some of our colleagues from Northern Ireland. And unquestionably, choosing a virtual event will result in a more quick decision. And I have got clients who absolutely sought to promote their appeal via virtual technology for that reason, that there is a perception, which I think is true, that you will get a quicker determination if you consent to a virtual inquiry. Of course, as we'll hear from Richard, a virtual event is a voyage of discovery for all of us and how it will work, and it will be very subjective, as is a physical inquiry, on the nature of who's there and the parties and the inspector. It's of course not necessarily quicker. The actual event is not necessarily quicker because of the more restricted hours that they sit. And of course, the virtual event will be dependent, as is physical inquiries, on the inspector. Of course, a virtual event will be less personal and require a different form of communication and practice. And that would be certainly true of barristers, witnesses, and all participants. And of course, it will change how third parties participate in the appeal, and it requires a lot more structure and discipline with timings, etc. So a virtual event, if you are asked your views, it will require serious thought and preparation, as Anjoli and Richard will now set out and explain. So I now hand over to Anjoli.
Thanks very much, Sasha. So as has just been mentioned, I'll be covering the topic of the preparation of evidence for virtual inquiries. So just to start off with an overview, the overarching feature and takeaway from virtual inquiries, as Richard will come to explain in a moment, is that they do comprise of shorter and more focused sessions on evidence at the actual inquiry itself. And also, inevitably, you're not going to get the same direct physical interaction with the inspector, with witnesses and with opposing counsel during cross-examination. And so what does this mean for the prior preparation of evidence? I'm going to be looking at proofs of evidence and appendices which are submitted by witnesses, the core documents, and then preparation for the day itself of giving oral evidence during the virtual inquiry. And the main lesson that there is to take away from this is that proper preparation from the outset is absolutely key. Of course, proper preparation for normal in-person inquiries is also important, but it's even more imperative with virtual inquiries. So turning first to proofs of evidence and appendices, as I'm sure you'll all be aware, witnesses will submit written proofs of evidence which cover their qualifications, their expertise, and their judgment on the matters in issue in that particular inquiry. And these are usually submitted to the inspector and exchanged with the other parties 4 weeks before the start of the inquiry. Now, there's not been any formal guidance or directions from the planning inspectorate yet about the preparation of proofs of evidence specifically for virtual inquiries. And that's because of the very few inquiries that have proceeded virtually so far. Evidence has been submitted and exchanged prior to the COVID-19 pandemic and before it was agreed that the inquiry would be heard virtually. But it will inevitably come where we have inquiries which are set to be virtual before the exchange of evidence. And I know from my experience representing parties where evidence hasn't been exchanged yet, we've been asked for our views on whether to proceed virtually or not. And so I expect once this starts to happen, we will see some more formal guidance from PINS on the actual preparation of evidence itself and whether this should be any different for virtual inquiries. But just in terms of good practice for now for proofs of evidence for virtual inquiries, as Richard will explain, and as I've already touched on, the nature of virtual inquiries is that sitting times during the days are much shorter and the evidence is much more focused. And that's because it is difficult to concentrate over a screen for long periods. That's been the feedback from some inspectors and also from judges in the Planning High Court, which James and Sasha have touched on, have been hearing virtual hearings since March. And it's inevitable that this should be reflected prior in the proofs of evidence. It's going to be even more important to have proofs of evidence that are more concise and really focus on the key issues and the questions that the inspector is going to have to answer in his or her decision, rather than what you might sometimes see as more long-winded proofs commentating on matters that are peripheral to what the inspector is going to have to answer. An important point is not to replicate the information that's already been agreed in the statement of common ground. There's much more emphasis by the inspectorate on having detailed statements of common ground, and so there's going to be no need to repeat all those points in your proofs of evidence. And also a particular point of feedback from planning inspectors is there's no need to copy large swathes of planning policy in proofs of evidence, often copied and pasted without any commentary on how it applies to the particular case. Rather, one should extract the particular relevant parts of the planning policy and explain exactly how it applies to your case. If any of you have participated in an inquiry in the last year or so, you'll notice often in notes sent by the planning inspectors after case management conferences that advisory word limits have started to be set. And I say that those are advisory because they're not mandatory. And I don't think in all the inquiries I've done that I've seen a single proof of evidence stick to that word limit. And that's because it's very difficult to do that. But I expect as we move forward, inspectors will start to more strictly enforce a word limit. And that's exactly what we've seen through written documents that have been submitted to the Planning High Court. Still touching on proofs of evidence, in terms of presentation and referencing, particularly in electronic proofs, it's always imperative to make things as easy and as seamless as possible for the reader, and in particular the inspector, who you're trying to persuade of your point of view. There's really no better way to annoy a decision maker than to have the documents in a mess. And so a lesson that's been learnt from the Planning High Court is to use hyperlinks or electronic bookmarks within your proofs of evidence, which when clicked on can take the reader directly to the relevant page further down the document within the appendices. It's also important to remember, even though we're working electronically and the inspector might have your proof of evidence electronically on his or her screen, not to simply copy links to the internet in your footnotes, because inspectors still won't browse the internet any more than they would do in normal inquiries. And so you still need to attach all the relevant documents easily accessible in your appendices or in the core documents. And it's going to be even more important to ensure that proofs and appendices are really immaculately presented. And even though it may take time to check that all the text and any photos you include and any plans appear properly sized and orientated when they come up on screen. So that if, for example, you share a document to everyone at the inquiry during your evidence, or if the inspector's got your proof up on screen, they can see it and view it properly. And it's going to be even more important because, as sometimes happens in physical inquiries, you can hand up easily a properly colour copied version of a plan or a bigger version to the inspector. That won't be able to be done as easily, obviously, in virtual inquiries. Finally, just a word on summary proofs of evidence. These do what they say on the tin. They often summarise your main proof of evidence and are sometimes a separate document or appear either at the start or the end of the main proof of evidence. And I touch on summary proofs linking to examination in chiefs. Now, if you've been involved in public inquiries, you'll know that examination in chiefs vary dramatically depending on the style of the witness and the style of the particular advocate. Sometimes you'll have witnesses reading from the summary proof or from the main proof or covering certain topics. But the key point is they can be very long. I've certainly seen examinations in chiefs and inquiries that I've been on and been involved in lasting an hour, sometimes even 2 hours. But because of the shorter timescales involved in virtual inquiries, it's likely that long and extensive examination in chiefs are likely to become less appropriate. And I think it's probable that reading from the summary proof, at least as the structure and expanding where appropriate, is likely to become more regular for examination in chiefs. It's an easy way to help the evidence be succinct and remain focused. And given the obvious lack of physical interaction, it does make it easier for the inspector to at least follow along while the witness is speaking. And so if you're going to be a witness appearing at one of these virtual inquiries, it's useful to bear this in mind when you're writing your summary proof of evidence rather than treating it more as an afterthought. Moving now on to core documents, which are the file of documents which will contain all the relevant documents for the inquiry and will often be quite long and extensive. The same points apply about these being well presented and easy to navigate, and the same lessons from the Planning High Court about having hyperlinked indexes or easily accessible electronic libraries of documents so that one can move straight to the relevant document. And an important lesson from the virtual inquiries so far, the one that Richard was involved in and also the one in Chorley that Sasha mentioned, is it's key to have this electronic library of all the core documents, are often accessible from the council's website, and to update these regularly throughout the inquiry. So to upload straight away at the end of every day various different inquiry documents that have been added throughout the day, or more core documents if they're added. And it's key with this that there's full cooperation between all the parties to ensure that this happens. And it really is in everyone's interest to do this, so there's no reason why there wouldn't be full cooperation. Finally, a final comment on preparation for the actual day of giving your oral evidence at the inquiry. There's the obvious practical matters. checking Wi-Fi, checking there's no light directly behind you. What about noise? These are all things that you'll have experienced, and certainly I have, during various video conferences and consultations that we've all taken part in during lockdown. A particular point when I was on a hearing in the High Court is that my bundle of papers seemed to be near my microphone on my computer, so that when I shuffled my papers around, it actually came across extremely noisily to everyone listening. So little things like that are always useful to check. Also, can you be in a different location to the rest of your team when you're the one giving evidence, or in a different room to the rest of your team, so as to be able to observe the PERDA rules when you're being cross-examined? And finally, it's also useful to think about the style that you've got when giving evidence. You'll naturally think about this when you're giving evidence in person at an inquiry, and there's no reason to treat it any differently when you're doing things virtually, especially when the lack of physical interaction means that it is going to be more difficult to engage with the inspector. So I think it's definitely worth doing a practice run with the video technology, particularly with a colleague, just to see how you come across on screen and whether there's anything that you think you could do differently or something that's particularly distracting. And it's little things like this, which sounds silly, but can make a real difference when you're putting across your evidence. And I've just included a link there as to a blog post I've written about this with David Locke Associates. So you can follow that through when you get the presentation if you want to hear any further on that point. I'll pass over now to Richard, who will be talking about the Case Management Conference and preparation for virtual appeals.
So good morning, everybody. I'm going to talk about the Case Management Conference and the virtual appeal itself. The background to case management is it's a new procedural stage introduced following the Rosewell review. The general purpose of it is to appoint an inspector early on so that they can take an active role in getting the inquiry ready for hearing. There's guidance in the PIN's procedural guidance on case management. And in particular, I've quoted from paragraph F10.2, which says that the note for the case management conference will be where the inspector sets out the key issues, the main issues for the inquiry, but also critically the way in which the evidence can address those so that the inquiry can proceed efficiently and effectively. In my view, this is now a really important innovation, and some critical tactical decisions need to be made at the CMC about what evidence is going to be produced and how it's going to be heard at the inquiry. In terms of the virtual case management stage, I've got 10 top tips. The first of which is to be proactive and discuss procedural issues with the other parties beforehand. Typically, the inspector's note for the CMC is circulated only a day or so before the call itself, which leaves very little time to think about what the other parties' positions might be. I think a much better procedure is in the upper tribunal lands chamber, where when they have a CMC in, for example, a compensation matter in the case of CPO, the parties are required to put in a position statement prior to the CPO, prior to the hearing, sorry, to discuss what their procedural position is on each of the issues, and they're required to cooperate in drawing up those position statements. I certainly found for my virtual inquiry, it helped to have spoken several days before to the advocate for the local planning authority. We'd identified what we agreed on, where we disagreed, and then the telephone call was a much more focused discussion about those issues. So secondly, I think it's important that the advocates identify all of the issues that are raised in the inquiry. And this is a theme that's coming through very strongly now from PINs in relation to virtual inquiries, that they are very keen indeed to make sure that third-party points are properly picked up at the virtual event. So it's not enough at the CMC to focus on the points raised in the reasons for refusal from the local authority. It's important also to comb through the third-party reps and identify their points and explain how they're going to be dealt with in the virtual inquiry. Thirdly, come prepared to discuss the form of evidence for each issue. As I'll explain, PINS seems to have some reluctance to deal with matters by round table in a virtual event. And so it's important that where you're having a CMC for a virtual event, you've really spoken to your team, worked out how they would prefer to present their evidence, whether it's round table, whether it's through cross-examination, and you've prepared a justification to try and persuade an inspector who may initially have some reluctance to use the mode of determination you favour. Then fourthly, really important to think about realistic time estimates, a timetable and witness availability. As you've already heard, virtual events sit for fewer hours, they tend to sit for longer time periods, more days, and so it's important at the CMC when you're timetabling to take that into account and not timetable as you would for a physical event. It's very unlikely that inspectors will sit late or condense a lunch hour, so one really needs to have sufficient sort of capacity at the end of the inquiry to spill over if necessary. Fifthly, as Anjoli said, it's important to have document preparation and management dealt with satisfactorily. There is no guidance on preparing core documents in the way that the courts have got guidance for electronic bundles. So use the CMC to raise this with the inspector. They'll each have their own personal preferences. Some will be used to working electronically, others won't. Ultimately, you're there to help persuade an inspector, so find out what their requirements are and try and meet them as far as possible. Then sixthly, make sure that the key members of your team are on the call and can communicate with each other. Typically, with an in-person CMC, I would get all the team together in chambers and we'd have the phone dialed into the CMC, and if a point came up we need to discuss, I'd mute it and we'd discuss amongst ourselves and then feed back to the inspector. Obviously you can't do that in a lockdown situation where you're spread around the country. We overcame that for my inquiry by having a parallel video con, so I could see all of my team on a Blue Jeans call. They could give a sort of thumbs up or a shake of a head and communicate with me that way, or use the chat function, and that worked really well. It was as if they were in the room. Particularly important to have your witnesses on that call, where you're, for example, discussing how their evidence will be heard. One of the issues was, should the 5-year housing land supply issue be dealt with by written reps, cross-examination, or a round table? And I found it really helpful to have my witness there giving his views that I could then feed into the call. Then next point, I think it's really important to pencil in a second CMC after the exchange of evidence. For my case, we had the initial CMC at early days of lockdown, and it wasn't clear what form of determination would be possible in June when the inquiry was scheduled for. So I suggested having an additional CMC at the very end of March, so that end of May, so that we could explore that and deal with any other housekeeping issues. It was really useful. It was only a short call, but I think it saves time because it avoids all the sort of faffing you get on the first day of the inquiry when you need to re-timetable because of people's availability. You can do all of that 10 days or 2 weeks before the inquiry and go straight in on day one. And our inspector seemed to be very receptive to that idea. So hopefully that's something PINS will have as a matter of course. Eighthly, the SCOT schedule, I think, is a particularly important document now for the virtual event. Many of you probably have come across these. It's either a SCOT schedule or a list of matters in disagreement. So PINS are now increasingly requiring parties to file a document with 4 columns. One, the issues in dispute, another column for the appellant and the local planning authority to give their position on each of those issues, and then a column for the inspector to write their comments. And we found that was a critical document because many witnesses gave their evidence in chief by reference to the headings in the SCOT schedule. Cross-examination was often structured in that way, and it served as a really good agenda for the round table on housing land supply. So because that document is central, it's really important that you timetable realistically for it to be prepared properly, and also that the witnesses are properly able to engage in it. Understandably, they're often focused on their own proof, but that SCOT schedule really needs to have their input and it needs to be consistent with their proofs. Ninthly, I think important to start thinking about the site visit early as well. Often you would, in a physical inquiry, sort of gather around a table and a map, and the parties would agree a route. Can't do that in a virtual event. So start discussing it early on. There may be third-party access requirements to some land, which may be more difficult to sort out in lockdown. Sort that out early on and involve third parties. PINS is very keen to involve parish councils, third parties, and they should be brought into the site visit route process early on. It also helps speed things on at the virtual inquiry if the inspector's done an unaccompanied visit by reference to an agreed route beforehand. And then finally, I think it's very important to encourage an inspector to be active rather than passive. Quite often inspectors can be reluctant to interrupt evidence in chief or cut across a cross-examination. But my experience was it was extremely helpful when the inspector raised concerns or questions that she had, because it helped to focus the debate and frankly save time. And that's a different way of working for many inspectors who do tend to sit back in a more passive role. So do encourage them to be forthcoming. Then in terms of the actual appeal itself, the technology we used is Microsoft Teams. That is the default choice of PINS. That's not going to change. They've been very clear about that. Inspectors are already familiar with Teams because they use it for internal PINS meetings, which is why that's been chosen. A number of people made representations on my CMC call that Zoom or other platforms were better, but it's clear that MS Teams is here to stay. You don't need Microsoft Office 365 to be able to use it. I've got it on my machine. Some of my witnesses just use the web app and we found no difference in performance. There's also a telephone number available to participate by audio only, and a number of members of the public used that. It was extremely helpful that PINS had a technology support officer, both at the test event we had a few days beforehand and also during the inquiry itself. A couple of occasions the inspector lost her audio for a few minutes. One councillor had problems because he was using Google Chrome rather than Explorer, and the technology support was able to sort that out very quickly. And overall we lost only a matter of minutes to technology glitches. And frankly, it was no worse than being in a town hall where there's a sort of dodgy microphone system and you can't be heard, or you can't have two microphones on at the same time, and you get the sort of kerfuffle about that. So we really didn't waste time on technology problems. I think it's important to practice using Teams beforehand so that everybody gets used to it. It's fairly intuitive, very few buttons to press. The important function to learn is screen sharing, both for advocates and witnesses, because the inspector was understandably keen that where documents were being talked about, plans or maps, or even text of a policy, where possible that should be shared on a screen so that everyone could see it, including members of the public. Also important to learn, I think, the keyboard shortcuts for turning your camera on, muting, etc. If you go onto Google, there are plenty of very short, very good video demonstrations on using Teams. In terms of the documents then for the inquiry, as Anjoli said, it's really important to have an electronic document library online and to update it regularly throughout the inquiry. That's particularly important for third-party participation. There's no physical inquiry library that they can dip into, so it really does have to be online and readily accessible. Particularly important as well that the documents are easy to navigate, so hyperlinks, use bookmarks, etc. It really will slow down the virtual event if proofs and core documents aren't easily navigable. As Anjoli said, it's also really important to check the size and orientation of your pages. Nothing worse than sharing your screen and then having to blow it up and rotate it. And that just takes unnecessary time. Important as well that when you're using a screen to view the proceedings, if you're the witness, your screen is actually large enough to see what is on it. One of my opposing witnesses was using his iPhone as the screen and using his laptop with his own documents on, and it was frankly useless sharing a screen with a plan that he was viewing on a tiny iPhone. So make sure you're using a big enough screen to be able to read what's shared with you. Hard copies are also, I think, an important issue to raise, particularly at the CMC. All hard copies have to go via PINS in Bristol, so there's no realistic opportunity to submit anything in hard copy during an inquiry, because it has to go into Bristol and then back out to the inspector. So if you're dealing with a case where it's important, for example, to look at architectural plans in A2 or A3, make sure they're distributed well before the start of the inquiry, so that the inspector has got them. Just a word about third parties. This is quite rightly a very hot topic for PINS. They want to make sure that virtual inquiries are fair and that third parties have a full opportunity to participate. And for the first 2 virtual inquiries that took place, what PINS has done is unilaterally give Rule 6 status to parish councils. So in my case, there were 2 parish councils, both of whom had made reps at the application stage and in response to the appeal. And they both held meetings and resolved not to seek Rule 6 status. But that changed when lockdown occurred. PINS contacted them and said, you must join the CMC if you can, and we're giving you Rule 6 status. What that meant is they weren't allowed to submit evidence at the very last minute, because proofs had already gone in by that stage, but they were able to have a slot of their own to present their objections that they'd already filed in writing. And also they were given the opportunity to question all of my witnesses for the appellant. And so that was a very effective way of marshalling all the public points and objections through the conduit of the parish councils, who were then given a platform at the inquiry to make those points. We also had a public session, as would be usual for members of the public to turn up and speak as well. And as I said, document sharing on screen was a particular requirement so that the public could see or follow what was going on. In terms of the practical arrangements for your team at a virtual inquiry, it's significantly easier if you're all in the same room. We weren't unfortunately able to be in the same room because of the lack of availability of hotel accommodation. Geographically, the team was spread all over the country, and so we had to find overnight accommodation, which we couldn't do. So 2 of my solicitors were in their offices in one city, 2 of my witnesses were in their offices in another city. I was at home, and the client and some of the other witnesses were in their homes. We found that worked perfectly satisfactorily. The way we overcame the problems was to have a WhatsApp group where we could communicate instantly amongst ourselves. So the equivalent of a sort of post-it note during the inquiry. Just really important if you're going to do that, to make sure that your phone is on throughout the inquiry, and you can see when you've got messages and alerts. Otherwise you're not picking them up in real time. So that was a good way of communicating. We had separate video calls at breaks and at the close of the inquiry, and it was perfectly satisfactory. The inspector was accommodating that we could have a mobile phone in our hand to be receiving instructions. She didn't find that discourteous, and that was perfectly okay. Ensure all your witnesses, though, understand the rules about not communicating during their evidence, or not using notes and crib sheets, because obviously they're not physically in front of the inspector and can't be policed in that way. It became standard to give a warning to witnesses at the start of their evidence to turn off all electronic communications. They had to confirm that they were alone in the room and they had no other cribs and notes, and that was fine. The inspector was happy with that. I know that Simon at his inquiry has had a different approach. What they've had to do is the witnesses during their breaks during their evidence have had to remain on camera, even when the rest of the inquiry participants go off for a cup of tea. So the witness stays there sort of almost on CCTV, say for when they need to go to the loo in a break, just to make sure that they're not cribbing or cheating. Personally, my view is that that's overkill. If you've got a professional witness who's signed a statement of truth and been told what the rules are, frankly, they ought to be trusted to be able to go off screen in breaks. But it will be interesting to see whether a standard process emerges. For my part, I think what we did at my inquiry worked satisfactorily. So the basic format of the inquiry is just the same as an in-person event in most respects. So formal dress, formal modes of address to the inspector, etc. It's only the inspector who's on camera plus the speakers, so the witness who's giving their evidence and the advocate who's either examining them in chief or cross-examining them. So you only get 3 people on the screen at a time. And that can be quite disconcerting because you have just at the bottom the series of icons with the initials of all the other participants, and you can't see their faces, you can't read the room. So it's very hard to judge how a point is going down because you've only got the inspector and the witness on screen. Everybody else is muted. The day is structured by reference to 3 sessions of 90 minutes. So we started at 9:30, ran to 11, had a half-hour break, started again at 11:30 through to 1, had an hour off for lunch, and then back again 2 till 3:30. That's because it is incredibly tiring looking at a screen all the time, as Sasha's indicated. That's been the experience in the courts, and the inspectorate, quite rightly, is adopting the same approach. There was some flex to run over to get to a convenient point of the evidence, but we didn't sit beyond shortly before 4 o'clock. And I think most inspectors are going to be reluctant to sit beyond 4 because by that time of the day, it really is very, very tiring. Another innovation is Monday sittings. We sat on both Mondays for my inquiry, which certainly helped to get the business concluded in the 2 weeks, but that could present a real problem. For people who've got back-to-back inquiries, Monday is often an important day to prepare the evidence or prepare cross-examinations for the next inquiry. It also presents problems, I think, within an inquiry because often one would use some of the Monday to prepare witnesses for their evidence in chief on the Tuesday, Wednesday of the second week. And if you're sitting in the first week right up until Friday afternoon, starting again on a Monday morning, you've lost that valuable con time on a Monday. So I think that's something that the Planning Environmental Law Bar Association and other interest groups may have to explore with PINs, whether Monday sittings really are going to be productive, particularly as Anjoli says, preparation is the key. And if you're being deprived of preparation time for future inquiries, are they going to suffer? So in terms of the other practical points about giving evidence, inspectors are asking for lists of documents that are going to be referred to by a witness or by an advocate in cross-examination, and for them to be sent the day before, so sort of typically 4:30 in the afternoon, so that they can get the documents ready on their laptop. So that does mean that you have to have prepared as a witness which documents you want to go to in chief, and as an advocate where you want to go in cross-examination in plenty of time. And again, on a Friday, inspectors were asking for Monday's documents at about 4:30 on a Friday, so no opportunity to do that over the weekend. Much harder to see a witness or the inspector whether they've actually got the document in front of them that you've taken them to. So it's really important to go at a pace that is manageable and frequently check whether everybody's on the same page, so to speak. I think another thing that clearly emerged from my experience was it's impossible to interrupt and talk over somebody. All you get is just a mash of sound when everybody's talking at the same time. So much more important to be looking at the screen and watching for visual cues to see if an inspector's wanting to jump in, raise a hand if you want to object rather than talking across somebody. In terms of witnesses, I think a critical point is certainly until we're all able to be in an office together in a sort of professional environment for a virtual inquiry, be wary of being too relaxed in your own house. If you're sat there with all your home comforts in your slippers giving evidence, perhaps you're not going to bring your A game to the inquiry. Others may give a better account of themselves when they're more relaxed at home, but I think get to know your team, get to know your witness, and work out who's going to perform best in that type of environment, and have a practice with the technology so that they're comfortable. I think the virtual platform gives witnesses much more time to speak, much more space to speak. So very important for witnesses to avoid waffling, to make their answers short, precise and relevant. time really is of the essence with these short 90-minute sessions, and I think inspectors will quickly get irritated by witnesses who launch into large monologues and don't give focused answers. I think tone is going to be really important. Be courteous at all times. It is very difficult to, I think, get cross at a computer screen. It just looks awful and is going to be counterproductive. So it's going to be about persuasion through charm and substance, rather than controlling a room with the force of personality, which perhaps in a physical event is more some people's style. And I think, as everyone said, it is more tiring, so witnesses really shouldn't be afraid to ask for breaks if they need them. And inspectors are very understanding of that. I've touched on this already, but I think there will need to be a guidance on how witnesses behave during breaks. Interestingly, the commercial court has a practice where if you're alleging dishonesty against a witness, then they're attended by a trainee from the opponent's team just to stand there and make sure that they behave themselves. So, I mean, in a standard planning inquiry, you don't have allegations of dishonesty, but I think that's a useful calibration, that the commercial court only thinks it's necessary to watch over somebody giving evidence where they're alleged to be dishonest. So I do think having sort of CCTV on a witness in a break is perhaps overkill. As I mentioned, round tables, PINS took seemed to be a general line of cancelling round tables that had been fixed at CMCs held before lockdown. And so for my virtual inquiry, the inspector gave us the choice of dealing with 5-year housing land supply, either as a formal cross-examination session or by written reps. And in the end, we persuaded her to reinstate the round table. We used the Scott schedule as the agenda, and it was fairly formulaic, hearing from one party, then the other, then going to the advocates if they got anything to add. But it did work really well, and hopefully, because all of that was recorded for PIN's internal training, hopefully we demonstrated that a round table can work in a virtual event. It is much harder. You can't have some sort of free-flowing discussion. It requires a clear agenda, and I think the Scott schedule is ready-made for that. It requires a proactive inspector who's come with their questions and is going to chair it quite firmly, but also self-discipline from the participants to not speak out of turn and not talk for more than their fair share of the time. So my own experience was a 7-day inquiry with 11 witnesses. It was an application for up to 150 homes on a field just outside the settlement boundary of a village, dealing with issues such as heritage, landscape, planning, transport, and 5-year housing land supply. So it was a fairly typical housing inquiry. It was a big step up, I think, from what the initial virtual practices PINs had been dealing with, where they were much more modest events. I think one of them was a case where the local authority was offering no evidence. So this was a proper contested inquiry, quite typical of a housing inquiry. We had very few technical glitches. As I say, it was a matter of minutes that were lost to the inspector losing sound. Unexpected problems were that the inspector's neighbour was in the middle of laying a patio, so she had to negotiate with the neighbour not to cut slabs during inquiry sitting hours. So that's obviously a problem that's potentially going to arise. We had a number of people who had young children at home, but they didn't interrupt the inquiry, but that's a practical problem. I think if you've got lots of people in lots of different locations, you've got the potential for interruption. We concluded on time, save for my closing speech, which took us like an hour over our timetable. We did conclude within the allotted time, and at the end, all of the participants thought it had been a fair and effective process. And hopefully we have proved to PINs that round tables can work virtually. My own view is that the evidence was fully tested, and it really did feel like a proper inquiry. We, after a few days, I think forgot that we were on a virtual event, and it really did become like an ordinary inquiry. Nobody was pulling their punches, and the witnesses were properly tested. I should say that another practical point is that you log in to the event about half an hour before the inquiry starts, and then PINs requires that you stay logged in throughout the day, because each participant is admitted individually. So if you log out at break time, it takes a heck of a long time for PINs then to log everyone back in again. So you're told just to leave your computer on, mute, and turn your camera off during breaks and during lunchtime. I think two points to note about that. One is if you're going to have parallel calls with your team, you probably need a separate device to be able to do that, because if you've got the inquiry in Teams all set up on one, you probably want a separate device to go off into another room and have your cons. Secondly, do make sure that you're muted. A couple of instances where people thought they were muted and they were having a discussion at lunchtime, which everybody in the inquiry could hear, and they had to be quickly reminded to turn their stuff off. So my concluding thoughts are that as a process, it does work. It tested the evidence fairly and fully, and involved third parties and all the main participants. So I think we've shown it can be done. It's vital, though, to have cooperation between the parties to keep the show on the road. Constant communication between the advocates to make sure that we're sticking to timetable, communication to prepare things like agreed conditions, notes on particular topics the inspector wants. So sort of close collaborative working is critical. I think the opportunities for public participation are potentially greater and cheaper. So where you've got a virtual event, a member of the public who typically would be working or have childcare responsibility and couldn't attend a physical event is able to log on or dial in and follow a particular bit of the inquiry they're interested with, and to make a short 5-10 minute statement, which otherwise they wouldn't have been able to. So I think there's an opportunity for more and different members of the public to participate. I think it's also cheaper because you haven't got to pay witnesses to have overnight accommodation or to attend for long periods of time. It may be that parish councils are actually able to use professional consultants to dip into selected bits of inquiries, and that's going to be a much more economic way that they can take a role in inquiries. I think the shorter focused hearing days mean that, as Anjoli said, written evidence has got to be really clear and focused. Cross-examination and oral evidence really have got to be on point. And the message again is proper preparation from the beginning is imperative. It reminds me very much of the famous Mark Twain quote, apologising for not having written a shorter letter, but he didn't have enough time. It really does take much more time to boil things down to their essentials and the key points, and that work does have to be put in, otherwise virtual events will overrun and I think not be as effective. So those are my practical experiences, and I think we'll go back to James now and answer some of the questions that I can see popping up in the question and answer bar.
Thank you very much, Richard, and thank you, Anjoli and Sasha. There are a few questions we've had in the question boxes, and also a few others I think that we wanted to address. So I was going to start, Sasha, with you. We had a question about whether there've been any enforcement virtual events. What's going on that?
No, Pins have been surprisingly quiet about that. I think they're wrestling with questions Richard's alluded to, questions of oath giving, etc., etc. But at the moment, as I understand it, and I've searched through, I haven't seen a communication from Pins informing us of the holding of a virtual enforcement appeal. So I think they're still crunching through the practicalities of that, as far as I understand it. But obviously, if such a thing was held, it would be pretty critical it was in the public and people had access to it. Yeah.
And then, Sasha, the other thing I was going to ask you was if we sort of take the Rosewell reforms and the advent of virtual inquiries, I mean, where does that lead to in terms of how parties have got to approach inquiries now?
Well, I think Richard's identified this. I think the days where you have clients demanding lack of cooperation and incredibly aggressive approach have just gone. I mean, I think, as Richard has said, the virtual inquiry demands cooperation. It demands an engagement with the LPA, all the appellants and the Rule 6 parties. Rosewell signalled this, the inspectors are signalling it, and I think the virtual inquiry format is just making it absolutely compulsory. So for all of us involved in the appeal system, I think we have to be collaborative and we have to engage in a productive and constructive manner.
Thank you. That's definitely correct. Which is a good. I mean, it's obviously a positive in lots of ways if that's where we end up. Anjoli, I was going to ask you. You talked about the possibility of PINs beginning to strictly enforce word limits for proofs. I just wanted to know what your view was, and maybe the others as well. How good an idea that is. You mentioned what the planning court does, and I lived for a couple of years under the strictures of that while doing the airports litigation, and I mean, literally spent hundreds of hours trying to eliminate just a few words, which is a very time-consuming, expensive exercise. So, what do you think? Is it a good thing?
I mean, I think a balance is required. I think in principle, yes, it could be a good thing because it would encourage the focus and concision that's needed. But obviously you need the right word limit. I think the one that's used by the planning inspector at the moment, the ones that I've seen, is about 3,000 words, which is far too short. So obviously it depends what the exact word limit is, but I think there's a certain length that could be cut out, yes. Yeah,
I mean, I think it would be useful to have some rules around, don't put excessively long quotes from policies in, don't repeat stuff in the statement of common ground. Those could be rules. But you're right, I mean, 3,000 words is not adequate, particularly in a more complex inquiry. And I think you have to be careful about where they set that. The other thing I was going to ask you, Anjoli, was in terms of evidence in chief. You talked about that becoming shorter. Is that a good thing in your view?
Yes, I think it is. I mean, it certainly still has a role, particularly when you've got members of the public who haven't read the proofs of evidence or new issues have come up, which can be addressed by the witnesses. But where you've got everything written in a proof of evidence, I think there's scope to have these evidence in chiefs much shorter. And if we look for comparators in every other area where you have expert witnesses, for example, in big commercial trials, that actually don't have any examination in chief. It's worked off the written proof and then the evidence is challenged through cross-examination. So I think it still has a role, but it could be shorter.
Yeah, I mean, it's interesting because I know that obviously probably about 20 years ago in civil trials, the rule was suddenly that all evidence in chief effectively went, other than if directed by the judge, and your witness statement stood as your evidence in chief. But I mean, I know that the evidence working group has been looking at civil procedure rules and are talking about reintroducing more evidence in chief, because there's a feeling, at least amongst some, that evidence doesn't come out quite right and in the right way unless you do it properly through evidence in chief. I mean, I am a big, I don't know what, interested in whether Sasha and Richard have got a view. I mean, I think evidence in chief is hugely important and often underrated. And I've certainly, I'm probably guilty of having carried out some pretty lengthy examinations in chief in my time. But personally, I think they are hugely valuable. I don't know whether Sasha or Richard have got a view.
I'd agree with you. I mean, I think what's always forgotten is evidence in chief is such a critical tool for getting the witness used to giving evidence. It's a very good, I would say, and I think we all suffer from doing it far too long. I think people feel examination chiefs have to effectively deal with every point, and I think that planning inquiries, they are far too long and torturous. I think the aspiration should be 30 minutes to 40 minutes and keep it short, sharp and clear. And that adds to a point I wanted to ask Richard about, which of course often in evidence in chief you're dealing, or you need to deal with new documents that have arisen. How in your inquiry did you deal as a matter of practice with introducing new documents? Did that arise?
Yes, Sasha, it did arise. It was made very clear by the inspector that we should try as far as possible not to introduce new documents. But if it was essential, she was prepared to accept them so long as it was fair. But we were required to give plenty of notice, send the document to the local planning authority and the parish councils, discuss with them and hopefully agree a position as to whether it should be admitted, and then also what response was going to be required, whether anybody was going to need to call a witness or recall a witness to respond to it. So it was very much, the message was avoided if possible, but if you're going to do it, try and accommodate it so it doesn't derail the timetable, and give plenty of warning. So the idea of sort of springing a rabbit from the hat, I think, is gone in a virtual event, and make the actual document instantly available online so that everyone can see what it is. I
say, and George Carman QC will be turning in his grave. I mean, that was his whole whole cross-examination style for every case he won, the rabbit out of the hat. But there we are. I guess the world's moved on. So Richard, there are quite a few things I think people have asked based on your experience. So I'm going to try and pick them up with you. I hope that's okay. I mean, one was, you mentioned that there seems to be a bit of reluctance from the inspectorate to have roundtables within inquiries virtually, which obviously ironically is the opposite of the drive that we had through the Rosewell reforms. But someone's asked, if there's a concern about that, how are virtual hearings going to work? Are they going to have to be more formalised processes with less of a roundtable approach? I don't know whether that's something you thought about.
Yeah, I think that the fear of roundtables not working virtually was misplaced, and hopefully in our inquiry we demonstrated it does work. It does require a very clear agenda and some self-restraint from the participants. So hopefully we've demonstrated it works. It's a inquiry that was recorded. PINS is using it for internal training. So I think my advice to anyone would be, if you think evidence is best presented via roundtable, push for that, and it can work. It requires the inspector to have had time to actually read in, to be able to chair the roundtable, and that may have been a factor. We had an inspector appointed almost at the last minute, so that we had an inspector who lived closer to the appeal site and could then carry out the site visit, and maybe she hadn't had the reading time, and that influenced her initial view about a roundtable. But my view is it works, and do push for it.
Okay, thank you. You mentioned inspectors being more interventionist. This has been one of my strong feelings about inquiries over many years, is that there is room for inspectors to be more interventionist, to tell parties that they're not interested in a particular point. Doesn't happen that often with inspectors. With a judge in court, it happens pretty sharpish. And I know it's about training, and I think that, if we're going to have more intervention by inspectors, there will have to be additional training to teach them to do the right things and to avoid the wrong things. But presumably, is it your view, Richard, it's a good thing to have the inspector intervening more?
I think it's a really good thing, because ultimately we're there to persuade someone, and even if they're initially against us, you know what you've got to work with. If someone's sat there impassively, you've got no idea what they're thinking. It's really difficult to engage with them. So I would much rather, whether it's a judge or an inspector, them firing questions at me or my witnesses, because then you've got something to respond to. I think the Scott schedule is a ready-made tool for them to use. You've handed them the list of issues in dispute, what the parties have to say about it in summary, and so there's a whole column for them to fill in with their comments for their own private use. So you've made it a lot easier for them to work out what the key issues are, and to raise questions about what you've written in your Scott schedule.
Yeah, because I often feel at inquiries, something gets raised and it sets off hair running, and lots of time is spent on it, and then it never features in the inspector's report. And I do remember that I did a big solar and farm inquiry once, and someone started this line about the fact that if you planted a certain type of tree, it might well look like the solar farm. And so this became a thing that everyone started picking. And eventually the inspector, after a couple of days, to his credit, said, look, I will not be including anything about these fictional trees in my report. So if you want to waste time asking people about it, you can, but it's still not going in the report. And that saved a huge amount of time, because we would all have wasted days and days on that kind of stuff. And I think that's what inspectors need to do more. So that's not really helpful, but they've got to do it right. I understand the sensitivities around it. It can go wrong. Judges can go wrong on occasions, and they will intervene.
Can I say something, James?
Yeah,
I, as a matter of approach, I often say that at the beginning of the inquiry, that I favour interruption and intervention. I'm happy to be told I'm going down a line which is of no benefit to you. And I think some of the more passive inspectors need that cue, because obviously some of our brethren, it is difficult stopping them in full flow and saying, actually, you're not making a point that I'm particularly interested in. So I just think it's good advocacy in planning inquiries to give the inspector that authority to interrupt, and it works well.
Yeah, definitely. Linked to that, Richard, someone's asked, traditionally witnesses would watch the inspector to see if they were interested in your evidence and understanding your evidence, i.e. taking a note. Do you still get those kind of clues from the view you get of the inspector on the virtual inquiry?
I think we did at my inquiry, but it depends on how your inspector's taking notes. So we had an inspector taking manuscript notes with a pen, and you could see her on screen writing and literally follow the pen. So that was as good as being in the room with her. If you've got an inspector who's got 2 screens or a split screen and is typing, you probably can't see that on the camera, and that would be much harder to get the cues. So I raised at the CMC with the inspector again to be proactive in giving cues to witnesses as to whether they were speaking at an appropriate pace, and sort of said, well, we're here to help you, so make sure that you can get what you need from the witnesses, and do give them a cue. And so she was very good at telling witnesses to pause or to carry on.
Yeah, and I think you probably covered this, but someone asked about, you know, how do you pass note? How does the team pass notes to counsel while they're cross-examining the other side, or while they're doing evidence in chief of your own witnesses other than themselves? And I think you said WhatsApp was a way of doing that.
Yeah, we use WhatsApp. You could have a separate device with a parallel video call and have the chat function on that. And then, I mean, you could actually then see your team, and they could be giving you sort of semaphore signals if they were sending you a message. Whatever works. I think it's just critical that you've got something that you're able to see. And it is hard to be constantly checking messages when you're cross-examining. But the benefit is the messages, when they come through, are legible rather than sort of illegible post-it note that gets pinned to your back in the middle of a physical event.
Yeah, and I think, you know, what comes from what you're saying is obviously the role of witnesses now in terms of their professional conduct is hugely important, because we are now much more reliant on witnesses to self-police their behaviour in giving evidence. They can't be watched in the same way they would be at a physical inquiry. So that's obviously more important now.
Definitely, yes. I mean, I think that's probably one of the reasons why enforcement inquiries haven't yet taken off virtually, because where you have got particularly factual disputes in an enforcement inquiry, where you might have to swear the witnesses on oath, I think there are severe issues about dealing with that virtually, with somebody not being policed. But my own view is where you're dealing with professional planning witnesses who've put in a document with a statement of truth and have been reminded of the rules, that they ought to be trusted to comply with them. And in a physical event, they'd pop off and have lunch. You wouldn't have someone watching them like a hawk at lunchtime. And it's no different really in a virtual event.
No, you mentioned cribs and notes. I mean, be interested to see what other people's views are on this, Sasha and Anjoli as well. I mean, I've never thought there was any objection to cribs or notes, as long as they're the witness's own cribs and notes. They can make any notes they like, can't they?
Oh, that's true. It's always slightly unreassuring when you see a witness going with 600 pages of notes.
Yeah, I agree.
Can I just ask, there were 2 points I just wanted to ask before we hear from Anjoli. Richard, someone's raised a sensible issue about your Scott schedule and whether you're able to, certain of these documents which would really help our audience, like the Scott schedule and the inspector's notes of the case management conference. Are they in the public domain first? And if they are, can we put a link on Landmark's site to show people what these things look like in preparation for their inquiries?
Certainly, I think the Scott schedule should be in the public domain. It's an inquiry document, so it's probably on the local council's website at the moment, but we can say, I'll check that, and if they are public, make them available.
Yeah, there's a few other sort of factual ones that, Richard, I think it'd be quite interesting. Do you know, did the inspectorate record the inquiry, and did they make the recordings available? It
was only recorded for PIN's internal training, and I don't think that's going to be standard going forward. I think the initial events are going to be recorded for training, internal training only. So it wasn't recorded by any third parties or for wider distribution. But given that anyone could audio record an in-person inquiry, I suspect it's going to be possible to record a virtual event in the same way, but with the usual requirement of notice and getting the inspector's permission.
And someone's asked how it works practically. If you're a witness talking to a document, do you put up the document and share the screen and talk to the inspector through it, or does the inspector control the documents on the screen, or is someone else controlling that?
It's not going to be the inspector doing it. It can either be the witness or somebody in the witness's team. So I think at my inquiry, it was always either the witness or the advocate who was talking to the document who was able to do it. But if you've got a witness who's perhaps not au fait with the technology, or actually would rather not have the hassle of having to share documents at the same time as giving evidence, there's no reason why they couldn't give a queue to say, could you please put core document X up, and then one of their team do that for them. Okay.
And there was a few questions about timing issues. So you talked about the inquiry being 7 days, and I think someone asked, was that was an extension of the time that it would have been for a real inquiry? Is that right?
It was. We were scheduled to sit for 5 originally, and then we were extended to 7, plus had the final Friday penciled in as a reserve. So 7 plus a reserve was what we were extended to. It would have been a full 5 days in person and probably spilled over into a 6th day, given the requirement to deal with third-party highways points. So I think it probably added a day and a half to the inquiry.
And that seems to be something, I think that's happening with the other inquiry that's going on now, the Chorley one. Simon Pickles is doing. The reason Simon was originally going to speak today, but he couldn't because that inquiry's gone over. But I think that's becoming quite common. It's adding, you know, a 5-day inquiry becomes a 7, a 6-day inquiry becomes an 8-day inquiry. We're going to have to get used to that and deal with it. It seems to be the situation. Yeah.
I think that's right. And there's also an issue with timing and closings, because we're not at the moment having a group site visit where at the end of a reasonably long inquiry you might have half a day or a day off while the site visit happens to do your closing. That's not happening. The inspector's going off on their own after the event. So we were straight into closings after having done the Condition and 106 session. So it can be quite busy overnight to get in.
Okay. I mean, that's really, and the other thing is someone's asked a question, which I think is a very useful question, and it flows out from what we were talking about a moment ago, which is that inquiries that are virtual are taking longer. And that is, has anyone got any sense, it's not necessarily for you, Richard, but has anyone got any sense about how bad we're getting into a situation around backlog? Because obviously we've got all these adjourned inquiries we've got to get in, plus the inquiries that would have happened, and they're taking longer. Has anyone got any sense about how backlogs are building up?
There is a significant backlog. I mean, my experience, and I know Anjoli and I are involved in an inquiry that was effectively is now programmed in November, and I think the appeal was submitted from memory in early May. So we're kind of in pre-Rosewell timescales now. I'm afraid that's the consequence of this. But I also wanted to say a point to Richard about. I think to be fair, Graham Stallwood, the Director of Operations at PINS, is very happy to receive feedback and comments from people. So I think for our audience, we should be telling PINS what we like and don't like. And one of the things I wanted to raise is the Monday sitting, because personally, I think that is problematical, particularly if we are in a world in September and October, potentially having back-to-back virtual inquiries. To have 2 to 3 weeks for us and our witnesses where you are in a virtual inquiry for 5 days is tough. So personally, I would like them to go back to the old inquiry way of Tuesday to Fridays.
Yeah, yeah. One other question that's been asked is that because the virtual inquiry procedure's new, are we likely to see more judicial review challenges by third parties complaining about aspects of the virtual process? What
my judgment, I know the planning court have reached a view, and I'd be interested in Anjoli's view, but I think the general view, and James, you know this, but the general civil courts have been pretty clear that they're not going to be particularly attracted to anyone alleging concerns over consultation process as a consequence of COVID. I personally wouldn't particularly like to go up and as a claimant to make allegations of illegality along those lines in the current climate. I don't think the courts would be particularly attracted. Do you?
No. Anjoli, do you have any thoughts?
Completely agree. I can't imagine a judge is going to be particularly sympathetic to that. And I suppose as we've seen in Richard's inquiry, the inspector was obviously keen to ensure that third parties become Rule 6 parties, to ensure that problem doesn't really arise.
Yeah, I mean, I think, it seems to me, if you make that challenge and you're running that case in the autumn, you'll probably be doing it virtually to the High Court, complaining that it's not fair to have had a virtual inquiry, which is going to be a tough one. But even if you don't, I mean, the reality is that natural justice and fairness has to be dependent on context, and the context that we're in is a massive crisis which means that we're required to do things in a different way. And I think, PINs have really, I think, gone out of their way to try and make this process as fair and accessible as possible to the public. And I really think that challenges around the process would struggle to get off the ground. And if you want to pursue, I think Sasha, you're right. If you want to pursue those points in front of the planning court, and particular members of the planning court, good luck to you. But I think it's going to be a struggle.
I think we all know who you're talking about. And also, there is a point about consent. From my understanding, is PINs have been absolutely diligent in asking parties about consent to the process so far. I don't know, Richard, if you can confirm this, but both parties in your inquiry virtual hearing effectively agreed to go down that road.
That's right. We consented to the process. And I think I'll also add that there are plenty of opportunities at the case management conference and during the inquiry, if a party feels that they're being disadvantaged or there's unfairness, to actively raise it with the inspector, and the inspector will try their best to accommodate. There was the technological support available. So anybody who sort of keeps quiet and then complains to the court afterwards, I think is going to be kicked out and refused permission, because there are plenty of opportunities to put it right if there's a perceived problem.
Yeah. I think you have to be careful about the consent thing, because I think, unfortunately, the reality is in planning inquiries that with third-party objectors and Rule 6 parties, and we've all acted for those as well. Delay is a really important weapon in your armoury to stop a development, and so, I think there was a problem earlier on with too many third parties not consenting, not agreeing to have it virtual, and the reality is that there's going to have to be compromise. I mean, if people don't want it, unfortunately, I think it's going to have to come whether they want it or not, because you can't just defer all these inquiries until such time as we can all get in a room. So, I mean, I think there are consents. Obviously, seeking consent is a good thing, but there must be limits to that. Sure.
And also, a point, just to get your thoughts on, is on what basis could an appellant or local authority refuse to have a virtual inquiry? Is it just because they think their case would be better heard physically? I don't think that would necessarily gain traction. Problems with the technology, probably not either. So it's going to be difficult to see on what basis an appellant or local authority could start to refuse to give their consent, really.
And I think particularly now that we're getting examples of them working well. I mean, Richard's clearly satisfied with the process. Simon hasn't indicated from Chorley a dissatisfaction with the process either. So I think once there are a body of hearings and inquiries done well, makes that contention even more uncredible.
Yeah, I mean, I think Simon's posted something on his experience on our website, and we've put it on LinkedIn. And I think he was, surprised at how positive the experience was actually, because it's something so new. So yeah, I mean, I think the more we do, obviously, the more normal it becomes, the less people are likely to A, object, and B, pursue a legal challenge around it. I mean, I think, as I said at the beginning, they are a reality now, virtual inquiries, and we are going to have to deal with them. So, well, thank you. I wanted to thank speakers again for the excellent presentations we've had today. Been really useful. I hope that all of those of you who've joined us have found it useful, and I hope we've answered. I think we've answered all your questions. If we haven't, let me know. You can email me, and I can get one of the panel to help you out, maybe. But I think we've answered nearly all the questions we had. Thank you very much for joining us, and good luck in your virtual inquiries in the future. Thank you very much, everybody.